Welcome to the Iowa Innovation Business and Law Center Summer Speaker Series. I'm Jason Rantanen. I'm a professor at the University of Iowa College of Law, and I'm the director of the Iowa Innovation Business and Law Center. And I'm happy to welcome you all to our Summer 2021 Speaker Series. This summer, the IBL Center is going to host 3 programs. In 2 weeks, on July 14th at 12 p.m., Professor Chris Seaman and Tuan Tran will be here to talk about intellectual property and tabletop gaming. The following week, on Tuesday, July 20th at 11 a.m., Iowa Law Professor Sean Sullivan will host a panel discussion on big data and antitrust law featuring Daniel Sokol, Michael Gall, and Rosa Abrantes-Metz. Today, however, it's my delight to bring to you Utah law professor Jorge Contreras to talk about Sui-Genericide, the voluntary creation of generic terms. But first, though, a few words about Professor Contreras. I first met Professor Contreras while standing in line for lunch at the 2010 Intellectual Property Scholars Conference. At the time, I was a nobody in legal academia. I'd been practicing for a few years and was about to go on the job market. But Professor Contreras warmly welcomed me. He's been incredibly welcoming for the last decade, and nothing that has happened since then has changed my impression of him as someone who is so open and welcoming to others. No one is faster to welcome someone to the room or more interested in hearing their thoughts than Professor Contreras. But what I didn't know back in 2010 was Professor Contreras' exceptional career. He received his Bachelor of Science in Electrical Engineering and Bachelor of Arts in English from Rice University, then attended Harvard Law School before clerking with the Chief Justice of the Texas Supreme Court. He then practiced with Wilmer Cutler & Pickering, Hale & Dorr for 17 years, 10 of which he was a full partner. He's taught on the faculties of Washington University in St. Louis School of Law, the American University Washington School of Law, and most recently, the S.J. Quinney College of Law at the University of Utah, where he's also a presidential scholar, an adjunct professor in the Department of Human Genetics, and serves on the scientific advisory boards for the Utah Genome Project. One of Professor Contreras' most significant contributions, however, has been in the area of technical standards. He's edited numerous books and dozens of articles that have appeared in journals such as Science, Nature, the NYU Law Review, and the Antitrust Law Journal. Today, he draws on his expertise in intellectual property law and standards to talk about the phenomenon in which a company, organization, or other entity voluntarily creates a generic term and then relinquishes it to the public rather than retaining control over it itself. He'll talk for about 30 minutes or so, and then we'll have some time for questions. You can use the Q&A function in the Zoom webinar to ask questions, and I will ask them of him. But first, let's hear from Professor Contreras. Welcome, Professor Contreras.
Great. Well, Jason, thank you so much for inviting me to this great series and to speak with you all today, and for that very warm and flattering introduction. I knew it would eventually come to fruition, but that lunchtime conversation after 11 years, has finally paid off. So here we are. So with that, let me try to share my slides with you. If you can't see or something goes wrong, please yell out anytime during the presentation. But I'll just go ahead and get started. And I also want to thank the Iowa Law Review. This piece and this work has been in process for a number of years, but this year it did come out in an article in the Iowa Law Review, and I thank the editors and everybody who I worked with. It was really a terrific team in getting this published. So what are we talking about here? Anyone who's taken trademark law is familiar with the concept of generic terms. So terms like aspirin, thermos, escalator, zipper, cellophane, even though at one time in the past they may have been protected by trademarks, they are no longer so. They have fallen essentially into the public domain by virtue of being generic. Courts have numerous tests for determining genericness of a name or a term. Generally, they can be summarized by asking whether the primary significance of that term in the mind of the public is the product or the producer, the source. As we know, trademark law is very much about indicating the source of a particular product or service. If something like zipper or escalator tells you the general category of product rather than its manufacturer, then the term is likely generic. All right. When we want to assert that a particular term, whether it's a registered trademark, a common law trademark, or just a term out there in the wild is generic, there are a number of ways that we do that these days. And these have been grouped under this semi-pejorative term genericide, which has been in use for at least 50 years. There is some debate about whether this is an appropriate term. I use it and have adopted it. So we can make terms generic during trademark examination. Someone can apply for registration of a term or part of a term that is generic, and the examiner can reject the application during examination on that basis, or after the marks are published, third parties can oppose the mark as generic. After a mark is registered, listed on one of the registries in the US, third party can bring cancellation proceedings against it. Genericness can be raised as an affirmative defense in trademark infringement litigation by someone who's accused of infringing. And believe it or not, there is actually even an avenue for public enforcement agencies like the Federal Trade Commission to challenge marks as generic, although that hasn't happened in about 50 years also. So there are many different ways to make terms generic, qualify them as generic. Entities that own these marks, however, implement countermeasures to prevent their terms from becoming generic. And zipper, again, fell to genericism many decades ago, but companies like Xerox have been very proactive in trying to convince the public that their marks, their names are not generic. And they have a series of clever ads in which they compare the term Xerox with zipper and other generic marks to show that, well, Xerox is not really like zipper. When you say Xerox, you mean photocopying using Xerox equipment. You don't mean the general category of photocopying stuff. Aggressive ad campaigns have been sort of mounted over the years by a number of companies. Probably the most notorious and fun of these is the Velcro company's ad, which, since we have 30 minutes, I'm going to play it for you. Many of you have probably seen this, but it's so wonderful that I think it sets the tone very well for what we want to talk about. So let's see if this works. All right, so if you are humming that song for the rest of the day, you know, my mission here is accomplished. But it's entertaining, and a highly talented legal staff at Velcro Corporation. Nevertheless, they spent a lot of money and a lot of effort to try to prevent people from using their mark generically and losing it to a claim of genericide. So, whoops, let's actually move on up. Let's see that again. All right, so trademarks, they're valuable. As we've seen, firms are spending significant amounts of money to avoid their marks from becoming generic. Yet, then I turn to the actual subject of this paper, which is there are firms, many of them, that are voluntarily designating terms that they have thought up as generic. And why is that? And that's really the subject of this paper. And it's something that really hasn't been explored in the literature until now. So let's think about this in a little bit of detail. This isn't a new practice, right? Go back to the 1940s, and you will find that a group called the Proprietary Association, which was a trade association for drug manufacturers, was starting to go to foreign countries, foreign trademark offices, to oppose the registration in those countries of common terms that were being used in the United States in English. Things like vitamin, antacid. Those are not words, those are English words. They're not German, French, or Spanish words. So conceivably, somebody could go to the trademark office in Germany or France or Spain and register vitamin as a mark. And that would cause problems for American vitamin manufacturers who then wanted to sell their products in that country. They could no longer call them vitamins because somebody else would own the term vitamin as a trademark in that country. The Proprietary Association had some success doing this in the 40s, but later in that decade, they were successful in getting the US government involved. So the Department of Commerce, sometime in the 40s, created something called the Generic Word Program. This was an official program run out of the Department of Commerce, expanded beyond pharmaceutical products to all categories of products that were interesting to US industry. And what would happen is the US Trademark Association, which is the predecessor to INTA, the International Trademark Association, which is the principal trademark trade association today, its members would submit words to it that they said, look, we think that these words shouldn't be registered in other countries. USTA would then submit those terms to the Department of Commerce, who would then undertake some efforts, diplomatic and so forth, challenges in local trademark offices to prevent those terms from getting registered as trademarks. And they actually had some success doing this with many different terms, right? So tractors, bananas, biscuits, all of these were potentially going to be registered in other countries as trademarks. But this program, led by US industry, got these terms that US industry kind of recognized as generic itself to be brought outside of trademark protection in other countries. All right. So let's think about the pharmaceutical industry, because that's where a lot of this began. Every drug generally has three names today. A proprietary name, which is often a registered trademark around the world, something like Advil or Motrin for sort of an over-the-counter pain reliever. Both of those products are ibuprofen. Ibuprofen is the active ingredient in both Advil, Motrin, and a handful of other off-the-shelf drugs. Of course, there's a chemical name for the compound, which is too long for me to pronounce. But it is advantageous in the industry to have that middle name, that common name, to refer to products that are basically the same thing. Let's take it as granted that no one can remember or pronounce the chemical names. So how did we get to this state where ibuprofen is recognized throughout the industry as a generic term for this type of pain reliever when this is a new word, right? The word ibuprofen did not exist in the English language before it was so designated. There is a process to get these common names created. When we're looking at the United States, there are two relevant bodies. The World Health Organization has a board that devotes itself to these international non-proprietary names. In the United States, these names are adopted by something called the US Adopted Names Council. There is a lengthy process, which I describe in the paper, which we won't go through in detail here. There are detailed rules about the nomenclature that can be used, what the prefixes, the body, the stem, suffixes of these different words can and can't be. Firms will propose common names like ibuprofen to the USAN. There will be a complex set of approvals or rejections, both at the USAN and the WHO level. And the result is that once a name like ibuprofen is adopted as an INN by the World Health Organization, most drug companies will refrain from trying to register it as a trademark. But as we'll see in a few minutes, that's not a given. There is no law or regulation that says you can't register the name ibuprofen as a trademark. All right. Drugs are not the only area in which common names are created. There are a whole range of these types of products. This effort to systematize the creation of common names really started to arise in a lot of industries after World War II. It was a combination of consumer protection, regulation, you want there to be a common way to inform people what are in some of these dangerous compounds like pesticides, what is in the products that they're buying. Synthetic fibers was a big one administered by the Federal Trade Commission, when clothing and linens and textiles were no longer just made out of wool and cotton. The FTC and Congress thought that people should know what is in that new shirt or dress that they just bought. Polyester, well, if we're going to tell people, we want them to know what the thing is. And most recently, and Jason alluded to this in the introduction, and this is the reason that I became interested in this area, we start to see this practice of creating industry-wide generic common terms for standards. Standards like USB, right? USB stands for Uniform Serial Bus, but any of us who have a computer undoubtedly know the little ports that we can use to power our devices, to interconnect them, and so forth. And even though USB was developed a good, 2+ decades ago by a group of companies that made computers and peripherals, they did not protect the baseline USB term, even though they have protected other marks. And the president of the USB Forum has declared in an opposition proceeding against a company who wanted to register the term USB house, that USB is a generic term. It can't be proprietized as a trademark. If you're going to use USB in a proprietary name, you must disclaim it during prosecution, just like you would, if you wanted to create a restaurant called Dynamite Burrito, right? Burrito is a generic term, generally would be disclaimed in your application. The World Wide Web Consortium, which has created many of the standards we use every day when we surf the web, went a step farther than USB by creating a list of terms on its website for standards that W3C created, but which it believes are and should be treated as generic. So HTML, HTTP, XML, others, which we're probably less familiar with, all are deemed by their creator to be generic terms. Okay, so why do this? Why should firms voluntarily give up potentially valuable names like ibuprofen, USB, HTTP? Well, there are benefits for the firms that do it. There is benefit in having a baseline term for the entire industry. It allows competitors from capturing those terms, and it enables your brand names to be more simple and distinctive. So Advil does not have to describe the symptoms that it relieves. It can be an arbitrary or a fanciful name, a mark that's quite powerful without calling itself a pain reliever. It also allows firms to compete amongst themselves using their brands as opposed to the generic terms that identify their products. This builds brand loyalty, of course, all the good things that we attribute to a trademark system. There are also benefits at the overall market level. Consumer information is the most important one. When the consumer is at the drugstore looking at a shelf that has Advil and Motrin and generic CVS ibuprofen, the consumer knows with some degree of confidence that all three of those contain the same active ingredient. And they know that without having to have a degree in chemistry and understanding what the actual chemical names mean. Allows comparison shopping, basically competition based on price, or if you will, the attractiveness of the package, company reputation, or whatever other indicia of competition you prefer. And of course, reduces consumer confusion. It also, as in the example I just gave, enables generic competition from non-brand products like the CVS or Walgreens versions of those products. All of these are benefits to the market. All right, that being said, it's actually kind of ambiguous as to how the law treats these self-declarations of genericide, or what I've called Sui-Genericide. So other forms of IP, and I'm talking about patents and copyrights, allow the owner or the holder of an IP right to dedicate it to the public. In the words of William Landis and Judge Posner, to depropertize it. And once that right is depropertized, it can't be reappropriated as property by anyone. So in the copyright world, since the 18th century, there have been doctrines that allow you to dedicate your copyrighted work to the public. More recently, Creative Commons with the CC0 designation allows you to take your copyrighted work and basically waive all copyright claims contributed to the public domain. With inventions that can be patented, there are more complex ways to make it available. You can publish your invention so it can't get patented. You can abandon an application. You can fail to pay renewal or maintenance fees. You can license it to the public under some sort of license. And all of these will, once they're done, once the dedication to the public happens, no one else can come along and obtain property rights on that contributed item, right? So I dedicate a book to the public domain. Someone can't come along and then copyright my book, my invention. I publish it. It was in an application that I abandoned. No one else can come take it and patent it. In fact, that abandoned application or publication acts as prior art, preventing later patents and patenting of improvements that are obvious in view of what I've done. The same does not hold in the world of trademarks, right? Trademarks are distinct from patents and copyrights in this way. And again, Landis and Posner identified this years ago. When I abandoned a trademark, either as an application or as a mark, I stopped using it in commerce, somebody else can come along and take it. And we have numerous instances of that happening. But when a mark becomes generic, it can't be reappropriated. Now, there are instances, a few, in which generic marks have been reclaimed, either by their owners or by others, after showing that the once generic term does now become an indication of source. But that's slightly different. When a mark is generic and it's still considered to be generic, it can't be reappropriated as a mark by anyone else. So how do we make this jibe with the idea of sui-genericide? What is the legal effect of sui-genericide? Genericide today, as I mentioned before, is generally determined in adversarial proceedings, either examination, ex parte proceedings with the Patent and Trademark Office, or a variety of third-party oppositions, cancellations, or litigation effects. What is the legal effect of a sui-genericide declaration, right? Not genericide determined in one of these adversarial proceedings, but just a statement. The chairman of the USB Interoperability Forum saying, yeah, USB is generic. Or W3C posting on its website 20 terms that it created that it considers generic, or pharmaceutical manufacturers all considering ibuprofen to be generic. What is the legal effect of that? Well, if we think about someone saying that somebody else's term is generic, PepsiCo, for example, saying, well, you know, the term Coke has got to be a generic term for a cola-based beverage, we're going to give very little credence to that statement. Obviously, self-serving statement that's not particularly believable. But what about self-declarations, right? This is a term that I created, and I say that it's generic. Do we give that any legal effect? Well, maybe there may be some reliance or estoppel arguments that the public could make to say that I said this term was generic, so I now shouldn't be able to enforce it as a trademark. But that's just going to bind me, and certainly it's not going to bind others who might want to go and use and or register that term as a mark. And interestingly, programs like the INN program at the World Health Organization, the USAN program, they really have no binding legal effect on trademark offices or under trademark law at all. In fact, they're barely mentioned in the trademark manual of examining procedure or TTAB proceedings in the paper. I tracked down the very scant references to these programs, and they're informative only, right? There is really no binding legal effect that they have in terms of trademark law. Despite protestations to the contrary, the WHO has published material that says you can't get a trademark on an INN, but of course, the WHO has no authority over what happens in national trademark systems. So what can we do if we think that it's a good idea to have Sui-Genericide available in a legally binding way with effect on the whole world as opposed to just on the maker of the statement? How might we do that? The way that I propose in the paper is to think about collective designations of these terms through lists that are developed by consensus. Industry bodies like pharmaceutical industry associations, associations of pesticide manufacturers, fiber manufacturers, plant cultivators, numerous different groups come up with these terms. As long as those groups are generally representative of the full industry, they're not pushing one particular company's products, and there is some due process that goes into how the names are created, those lists should be pretty reliable, at least in terms of what the industry itself thinks. And those groups could publish lists of common generic names, just like the USAN and the WHO do. They do this today. What legal effect can we give to these lists? Well, there are a couple of ways that we can do this. They can be used in trademark examinations. They're not, but they could be. At the most basic level, the trademark examiner could reference those lists. A mark comes in, or an application comes in to register a new mark. The examiner could consult the list of WHO INN terms to make sure that someone's not trying to register such a term. And if it is, to give extra scrutiny to that application or refuse it, reject it. A little bit further along the spectrum, you could give a presumption of genericism to terms on that list. So this could have effect both in the examination process as well as in litigation and cancellation proceedings. If I, for example, am selling ibuprofen at my drugstore, and drug company comes along and says, well, you're infringing my trademark. I consider ibuprofen to be part of my mark. I can then rebut that with a presumption of genericism, that if the term ibuprofen is on the INN list, then it should be presumed generic. A presumption that can be overcome, of course, by the asserter, but which does at least give some legal credence to the fact that an industry group deemed this term to be generic for all of the good efficiency reasons that we talked about a moment ago. So that's really the proposal. That's where I leave it. I would love to talk with you in more detail, answer any questions that you have, and explore this, or we can all just get together and sing the Velcro song again, if that's what you prefer. So thanks very much.
Thanks, George. That was fascinating. I found especially interesting the parallels and contrasts with other forms of intellectual property law. I mean, this is really I mean, you think about the way you can depropertize those, and you can basically make it so nobody can have rights over the things that have been depropertized. But trademarks are so different, and it's another way in which trademark law really differs from patents and copyrights. It's really fascinating. So I want to talk a little bit about standard setting, and whether you've seen instances where parties in standard setting organizations have done what they've sometimes done with patents, which is, filed for a patent on the thing that the standard covers, and whether you've seen this at all with terms. So have you seen instances where members of standard setting organizations, maybe those on the fringe who are watching, do try to actually register the term, as it's being discussed as a standard term in the industry?
Oh, I see a member. I mean, so this happens sometimes. So Bluetooth, for example, was originally created by Ericsson. And Ericsson, came up with the mark. Ericsson's a Swedish company. Bluetooth was some Swedish king in the 1000s in ancient times. And yeah, they eventually did assign over their rights to the Bluetooth Special Interest Group, which maintains it. But that's different. That's where an entity sort of created the term and then hands it over to a standards body. You're talking about some more sneaky behavior, right? Where we're coming up with a standard, we're going to call it Wi-Fi, but somebody sneaks out and registers the mark Wi-Fi before we get to it. It's interesting. So I've got other papers and studies about marks in the standards world. I mean, most standard names aren't actually registered as anything. I mean, most are just numbers, right? So 802.11, it would be a pretty good mark, right? Because it's arbitrary, be very strong, and this is a complete footnote and aside, but there is a whole series of marks that are just numbers, right? So Levi's 501 jeans and a Porsche 911, right? These simple numbers are strong marks because they're arbitrary. But that doesn't happen in the standards world. Most standards organizations don't register their marks. They often just register their house name, so the name of the standards body. And in the small standards bodies, that are basically single purpose entities, so Bluetooth, HDMI, USB, right? Because they've registered the name of the entity that applies to the names of the standard as well. And usually the registration happens before the work begins on the mark. So where you would run into a problem is someplace like IEEE, which is a big standards organization that's creating lots of standards. So something like Ethernet, right? Which is the wired sort of high-speed connectivity among computers and servers. Ethernet is a term that people at IEEE came up with. It's not IEEE name itself, and it's not just a number. It does have a number, and I forget what 803 point something. But the name itself is registered, maybe registered, maybe not registered. No company has gone out to register it, as far as I know. Wi-Fi is different. So we refer to the 802.11 series of standards as Wi-Fi. And Wi-Fi is a trademark, it's a certification mark, not owned by IEEE, the standards body, right? There's a separate group called the Wi-Fi Alliance that was created specifically to license this mark and create certification programs for Wi-Fi. So could you have a third party who goes out and sort of hijacks a name of a standard in development? You probably could, but at that point, it's probably not that difficult to change the name of the standard. And then once the standard is released, I don't know. I don't want to get too far afield from this paper, but the variability in the world of marks and names for standards is huge. And we're studying this with some collaborators like whether they're registered as certification marks or trademarks is very unclear. Sometimes both, sometimes one versus the other. Remember, the standards body doesn't make products. It just produces these written documents. And so, what classes you register these marks in is another sort of weird question that hasn't been fully answered.
Actually, I have a question that branches off of that. So you talk about estoppel, right? So thinking about how you could actually implement this in a more formal way, right? The concept of sui-genericide. So, I mean, one possibility might be part of a pledge, right? So if you were entering into, say, a standard setting organization or something like that, you pledge that this mark or this term is generic, and I agree that this term is generic. Is that something that could work as part of a standard setting process?
Certainly, it could certainly work with respect to the original, quote unquote, owner of that term. But the estoppel and the pledging arguments, they don't work that well as far as third parties, right? So someone could appropriate the term, no matter what I said about it, right? I say, I think that, Coke is a generic term for a soft drink. Well, that has no effect on the Coca-Cola company. And I think in these standards bodies, there's obviously a lot of gamesmanship that goes on. And what you don't want to happen is companies sort of putting forward their competitors' names, as these generic terms. And that certainly could see that happening.
Yeah, that seems like a really big risk. I mean, if you have, the standard setting saying, okay, we're going to basically take your mark, and that's going to become our generic term, right? That could be very, very detrimental for participation in the standard setting body. So another thought that I had as I was thinking about what you propose is you propose these consensus lists and you give them at a various formal characteristics we might treat them. Why not go a step further and say, we're going to have a generic registry and it's going to have terms and, what the terms are, the generic term for, it has to be some kind of correlation there. And then people can oppose entry of a term on the generic registry, and we'll maintain this, right? The PTO will maintain a reverse trademark registry, so a generic terms registry. Why not go that far? Are there problems with that approach?
No, that's a nice idea. But where do the terms come from, right? I mean, at some point, somebody's got to originate them. And at least in these historical examples, the terms generally come from industry groups, right? So ibuprofen, somebody came up with that. And the INN, USAN, they have these complex sets of lists and rules about how to come up with the words, whether a generic drug name should end with ifil or izine or atrazine, right? I mean, they're hugely detailed. But those rules are different. They're different for pharmaceuticals than they are for pesticides or for fibers or for plant cultivars. And so the words are going to be created in these industry-specific groups. Could those all funnel their results into a big PTO database? Sure. And they probably should. I mean, especially, my idea was to have examiners consult these lists. It's certainly going to be easier for the examiner to consult the big PTO list of all of this stuff. But I think that it would be, again, probably an unnecessary layer of bureaucracy to have the PTO involved in the actual creation of these names. And that's actually happening pretty well, in the industry groups.
So, based on what you've seen so far, are there industries where this practice is more common? I mean, certainly the pharmaceutical industry, maybe the standard setting industry, although you have, the certification characteristic there, the certification mark characteristic. Are there other industries where you see this is pretty common or really not common, where there just is not this voluntary creation of generic terms, thus leading to problems down the road, right? Velcro becoming the generic term.
Yeah, so most industries where the thing, right, that is the subject of the products is something with a complicated chemical structure, right? Or something that is difficult to to pronounce or to remember. You get these sorts of common names. But foods, is an area where you get this a lot also, often without significant regulation, right? So beef, everything from the different cuts of steak, right? Uh, and I don't know if you're familiar with the protection of meat cuts. There's a very nice Planet Money podcast called "Can You Patent a Steak?" The answer, of course, is yes to that question, because we do have standardized cuts, rib, loin, flank steak, and so forth, and these are standardized. And you, as a beef producer, you couldn't really trademark the term flank steak, for your type of flank steak. But if you're Delmonico, you can create a new cut of beef in which you do trademark the actual cut, like how you carve that piece of meat out of the animal carcass. It's unique and trademark. But all sorts of foods, right, have these common names. What is iceberg lettuce versus butter lettuce? That to some degree, these are based on species, the actual taxonomic origin of the plant, but necessarily. It is much oversimplified. There are lots of sub species of different plants that we lump together and call them the same thing. But again, a food producer couldn't trademark the term iceberg lettuce, most likely because it's been genericized. I through the corner of my eye and see somebody mentioning rollerblades, which is, again, takes me back to my youth. Actually, I don't know why rollerblades aren't that popular, but
So the question is, it took rollerblade an entire decade to come up with the bite-size category and generic term inline skates, which may explain city ordinances around the country forbidding rollerblading in certain locations and parking garages and posting signs against rollerblading. Should it be advisable for brand owners to spend time, money, and effort coming up with a generic category term when they launch their brand in forming an entirely new product category?
Well, they definitely should. I mean, that's just a good business practice. I mean, this paper aside, just the rules of genericide I would think, should urge anyone who's coming up with a new product category to come up with a term for it, right? I mean, this is Kleenex, escalator. Fascinatingly, right, the first escalators were created by the Otis Elevator Company. They were just Otis escalators, and Joe Miller and Lydia Lauren in their IP survey book talking about this, talk about what brand equity Otis Corporation could have had if it had simply called this like the Otis escalator moving staircase, right? We would have been calling all of these moving staircases instead of escalators. So yeah, I think the answer is yes. It does involve some extra trouble, and moving staircase, maybe it never would have caught on, and then you've wasted some time. But I would say the answer to that question is definitely.
So now I'm going to give you another example, which I'm thinking of, which is the Apple industry, right? I don't know how much you've been following the Apple industry, right? But you've got these creation of these new products that are protected by plant patents, and then they're given their distinctive names. Like we had the Honey Crisp, but now we've got the Sweet Tango and the they've got, and these are trademarked. They're seeking to protect the thing. How does that fit into your overall theory of Sui-Genericide? I mean, shouldn't they be also attaching some sort of common name to these products?
It's a big issue, right? Apples and plant cultivars in general this is a problem because those patents will eventually expire that cover, say, the Honeycrisp apple or the Granny Smith apple, right? Once the patent expires, anyone can make the product. But somebody may still have the trademark, right? The trademark will last forever, even when the patent is expired. And so you get this with, for example, roses, right? I honestly don't know the dynamics in the apple industry that well, but I did have a student a few years ago who was a horticulturalist before she went to law school, and like explained that this is a huge problem with respect to greenhouse plants, because plant patents expired decades and decades ago. But the companies who first, got the trademark on whatever that thing was called, the Teacup rose, for example, they can stop anybody else from marketing or selling a teacup rose, even though it's the exact same plant. They have to come up with some other name for it. And this genuinely creates consumer confusion. And it gives more of an appropriated right to that original trademark owner than they were entitled to under the patent. And so should something like teacup rose become a generic term? The answer is probably yes. But unlike the pharmaceutical industry, right, in the cultivated plant industry, there's not that intermediate layer of common names. Like, yes, the word rose, of course, is a generic term in the English language, but there are literally tens of thousands of varieties of roses, and they're quite different, right? Climbers and bushes and miniatures and whatever. So to distinguish them, you often want to use that proprietary name, but you're not allowed to. And so there's a large amount of confusion, and consumers are probably paying a premium. It eliminates competition in these markets, again, for unpatented products. And that's an industry where we probably should have greater genericide.
Great. Well, we're just about out of time, so we have time for one last thought. So what's your big picture takeaway from this? I mean, what should be done in order to, I want to say deal with, because this isn't an issue, but to improve the effect of Sui-Genericide when firms, when companies, when organizations actually want to create a generic term and have it be a generic term that others can't come and appropriate by claiming trademark rights in it?
Yeah, so sort of big picture, in the trademark world, there have been some important papers recently by Jeannie Fromer and others, sort of looking at the world's store of words, and we're running out of words, right, to become marks. A lot of the world's words have been appropriated as trademarks. Against that backdrop, in other areas of IP, we talked about the commons, right? And innovation can flourish in areas like open source software and so forth, or online content and photographs that are made broadly available, right? IP owners have made rights available so that others can use them. This hasn't really happened with trademarks. And, there are some inefficiencies that can arise when, consumers can't easily distinguish between different types of products when they're being offered by different vendors if someone can appropriate their names. And so, I think trademark law, it's different in many ways than the other forms of IP that we, generally, at least I generally have thought more about. And I don't think it has to be, right? We can apply some of these thoughts around the commons, around appropriability to trademark law, and I think we create beneficial effects, primarily for consumers and price competition.
Terrific. Well, thank you, George, for coming and speaking with us today and talking more about Sui-Genericide, which I think is a totally fascinating topic. So with that, we're going to close today's program. join us in 2 weeks on a Wednesday, so Wednesday, July 20th, when Professor Chris Seaman and Tuan Tran will be talking about intellectual property and tabletop gaming. So we'll see you then. Thanks again for joining us.